This is our case model presentation on the health coverage and care of undocumented immigrants. My group members are Ashley Castano, George Pfeiffer, Cameron Fink, and Tristan Woodruff. Mr. Smith is a young man without health insurance or verified immigration status. He is seeking care at a state-funded hospital in Colorado for neuromyelitis optica, or NMO. Some of the treatments for NMO can be very pricey and often require donation from pharmaceutical companies if the patient is uninsured and unable to afford the treatment. This donation is prohibited when the immigration status of the individual seeking treatment is unable to be determined. In this case, there are several ethical considerations to be made. To start, providing state-funded treatment for the man before determining if he is a documented immigrant could potentially violate state laws. Additionally, failing to disclose his immigration status to the pharmaceutical company offering to donate treatment would violate the integrity of the pharmaceutical company and their ability to make these donations in the future. Finally, the denial of medical treatment is equal to abandoning the patient who may urgently need the care. Mr. Smith deserves treatment for his condition despite any immigration or insurance status he might have.
In regards to ethical principles and concepts, we believe that Mr. Smith should have the ability to get treatment for his neuromyelitis optica. Addressing autonomy, Mr. Smith should have the ability to choose to seek healthcare without fear of rejection or legal trouble. Healthcare was never intended to be biased in immigration status. A quote from the Journal of Ethics says, "Our health system should in no way allow the care of someone who is seriously ill or injured to be compromised because of citizenship status. We have a clear mandate to provide medical care to all who enter our health system." Additionally, the state laws that were described in Colorado were designed to deny state-funded medical services to individuals whose presence in the U.S. is unlawful. There are specific circumstances in which the law could allow or require medical care for undocumented persons in state facilities in order to stabilize or in an emergency medical condition. The question here is who gets to decide whether or not Mr. Smith's condition is deemed to be overruled by this law and for him to undergo surgery. Just as Mr. Smith has the autonomy to seek treatment, there should be an autonomous decision by the person treating him to overrule the law and allow him to seek medical treatment despite his status. In regards to beneficence, a proper display of beneficence in this situation would be treating Mr. Smith, who needs medical attention, regardless of prohibitions or ability to pay. We must allow Mr. Smith to be treated regardless of citizenship status or financial capabilities. A hospital is a place where one goes to seek medical help. All other variables should not be considered when a patient needs treatment. The physician would be acting in beneficence by understanding Mr. Smith's dilemma and treating him for NMO nonetheless. Under the law of EMTALA, all hospitals that have emergency departments and receive federal funding must provide urgent care to all patients regardless of the patient's ability to pay. By virtue of EMTALA, any person, citizen or not, who presents to a Colorado hospital with an emergency medical condition is entitled to whatever stabilizing care that hospital can reasonably provide. Thus, if Mr. Smith, who presents with NMO, has visual loss or progressive limb weakness on arrival at an ER, then he must receive care for those symptoms that is consistent with prevailing standards of medical practice. This law also allows hospitals to do their jobs of providing treatment to those who live in Colorado and the surrounding areas. In this situation, non-maleficence would be treating Mr. Smith in attempts to avoid worsening his health. If we turn our backs on illegal immigrants when it comes to healthcare, then we are degrading humans based on a certain status. This should not be the case whatsoever. This creates a stigma towards immigrants and those without proper health insurance. Instead, physicians and lawmakers need to act in non-maleficence by allowing these people to be treated and providing the means for their treatment to be funded. If physicians deny a patient treatment that could help alleviate symptoms and prolong life, then they are going against the Hippocratic Oath of doing no harm. In order to practice justice, Mr. Smith needs the right to be treated in a healthcare setting regardless of financial or citizenship status. As stated earlier, when it comes to healthcare, everyone deserves the right to be treated. We provide healthcare access to the millions of unemployed people in America, convicts, prisoners, foreigners, etc. Why should we deny treatment and health to someone just because they don't have legal papers? In this scenario, the hospital is actually not required by Colorado law to inquire into the patient's immigration status before initiating treatment. Therefore, each patient is justified in receiving initial treatment of the healthcare team and understanding what the chief complaint is in order to determine if this is an emergency or not.
It is important to consider the historical context of immigration in the United States and how it relates to a lack of health insurance. There are about 12 million undocumented immigrants that live in the United States, making up 3.5% of the total U.S. population. More than 45% of these undocumented immigrants are uninsured because of the limited access to employee-sponsored insurance coverage. They do not meet the eligibility requirements for coverage through Medicaid, CHIP, and the ACA marketplace. Undocumented immigrants are often hesitant to reach out for medical care due to the fear that healthcare providers will report them to immigration agencies. They also fear that they will not be able to afford the necessary recommended treatments. An additional barrier to immigrants seeking care is the cultural or language barrier. About 9% of the total U.S. population speaks a language other than English at home. It is necessary that healthcare organizations have providers that are able to speak the language of the individual seeking care in order to communicate the treatment options and implications of this care. In addition to these barriers for undocumented immigrants, the lack of health insurance plays a role in patients not receiving proper health care. Data from the U.S. Census Bureau indicates that a total of 27.5 million Americans had no health insurance during 2018. Seeing how no major health policies have been implemented by the federal government, statistical predictions indicate that numbers are likely to be even higher by the time the Census Bureau publishes the stats for 2019 in September. According to the CBO, the number of American citizens who are uninsured in 2020 is around 31 million. The Affordable Care Act has made it possible for many otherwise uninsured people to obtain Medicaid and also marketplace coverage. When it comes to deaths due to lack of health care, according to the Institute of Medicine, an average of 18,314 Americans aged between 35 and 64 years old die annually due to the lack of health insurance. The high cost of insurance is the reason for many people today to not buy health insurance despite the creation of the ACA. In fact, around 73% of those who were uninsured in 2019 claimed that it was because of this high cost of health insurance. The stakeholders in this case include both documented and undocumented immigrants, and more specifically, Mr. Smith. It also includes individuals who are uninsured, state-funded hospitals and healthcare organizations, pharmaceutical companies, state and federal governments, and the United States, and more specifically, Colorado. The U.S. Constitution declares that Congress shall have power to regulate commerce among nations, to establish a uniform rule of naturalization, and to make laws which shall be necessary and proper for carrying into execution the foregoing powers. Congress has enacted laws respecting criteria for immigration, procedures of securing lawful entry and eventual citizenship, and penalties, including deportation, for unlawful presence in the U.S. In DeShaney v. Winnebago, the court held that the state was not constitutionally bound to seek custody of an abused child where state social workers had received reports the child was being abused. The court reasoned that receiving the reports did not establish a special relationship between the state and the child that would impose a duty of care on the state, implying the citizenship alone does not entitle one to receive beneficent state services. Federal or state governments may, through legislation, take on obligation to provide health care for citizens, but they are not constitutionally obligated to do so. The Personal Responsibility and Work Opportunity Reconciliation Act of 1996 allows all immigrants to receive emergency medical services, immunizations, testing and treatment for communicable diseases, and any other assistance necessary to protect life or safety except for organ transplants. The Emergency Medical Treatment and Active Labor Act, otherwise known as EMTALA, requires that a hospital emergency department must provide for all individuals that arrive to determine their level of need and subsequently stabilize their condition or transfer them to a facility that is able to provide them with treatment. Colorado requires that the state verify the immigration status of each individual who applies for federal, state, or local public benefits. This verification is exempt, however, when the care or benefits are required to treat an emergency medical condition. This is similar to the implications that are set forth in EMTALA. The state statutes work hand in hand with the laws enacted by EMTALA to determine the eligibility of an individual seeking medical care. Colorado's adoption of an attrition by enforcement strategy for undocumented immigrants could be complicated to physicians who want to help patients. The Colorado statute does not specifically require physicians to act as inquisitors but some Colorado physicians are state employees and work in state facilities, and their patients could be effectively removed from their care as a consequence of inquisitions by other state employees. The physician and the pharmaceutical company could be in a relationship of full disclosure. The corporation's governing board can decide whether or not it's in the company's best interest to restrict donation to lawful residents or to offer its product to anyone who might benefit. Issues relating to corporate image, corporate ethics, policies underlying immigration laws, and relations with clinical providers and investigators can be addressed in the board's deliberations.
In terms for the resolution of this case, alternative one would be that the Colorado State-funded hospital treats NMO patients with unverified immigrant statuses and those without proof of health insurance if they are unable to pay for treatment or need some sort of aid in this payment. The pro of this is those who that fall under this category or lack, health insurance or immigration status will not be afraid to seek medical care. It helps alleviate financial stress or emotional, physiological, and biological stress of the patient, and it will also decrease the amount of people that need to be treated for NMO, as NMO does affect 1 to 2 per 100,000 people, and NMO does occur in individuals with all kinds of races, and so this will help
by showing that this impacts a large portion of society, and by these people receiving aid from pharmaceutical companies, then it will positively impact several groups. And treating NMO patients at state-funded hospitals will open the door for other rare conditions and diseases to potentially also be treated as well. The con is that the hospital could get in trouble for treating a patient who is not a verified immigrant. This could produce lawsuits, and it could be unlawful in certain states such as Alabama and Arizona. Mr. Smith's suggested treatment of a monoclonal antibody can cost up to $17,000. This is very expensive for his type of treatment since his condition is very rare, and eventually all the state funding will quickly diminish, and there'll be no funding for less pricey procedures and treatments. Mr. Smith's condition will progressively get worse, and he'll eventually die due to complications from NMO. And so although there are treatment options available, they are unattainable for him. Alternative 2 is that the Colorado State Funded Hospital will not treat NMO patients and unverified immigrants and those without proof of health insurance, since they cannot pay for the treatment and do not receive any sort of aid or payment. And the pro of this is it would keep the integrity of the pharmaceutical companies intact and allow them to continue making donations in the future. A significant amount of tax dollars go towards funding healthcare for those who can't afford it. Many Americans do not want their tax dollars providing care for people who are illegally residing there. And they are better and more important things than those taxes can support: health interventions, education, fixing infrastructure, roads, disease preventions. The cons of this is that not treating Mr. Smith could create unnecessary discrimination in a healthcare setting. Healthcare providers have no affirmative legal obligation to inquire into or report federal immigration authorities about a patient's immigration status. If there's no obligation to look into immigration status of a patient, then there is no reason to turn away a patient who may or may not be a citizen of the U.S. And refusing to treat a person with drastic health needs creates inequality and injustice that should not be tolerated under any circumstances.
Our disposition is that Mr. Smith should receive the treatment that he needs for his neuromyelitis optica. Even though his immigration status is not verified and he does not have health insurance, Mr. Smith should not be forced to suffer from NMO if there is something that can be done to help him. It would be unethical to deny him treatment for his debilitating condition, as he is still a human and deserving of the same rights to health as any other patient. In addition, by knowing that there is a treatment option, despite the price, the doctors are denying him proper care, which is harmful to his well-being.
These are our references, and thank you for watching.